How and by whom is a default created? The 2008-2009 real estate collapse, also known as the housing market crash, was triggered by the burst of the subprime mortgage bubble, leading to a financial crisis that severely impacted buyers, sellers, and the broader economy. Leading up to the crash, banks and lenders issued risky subprime mortgages to borrowers with poor credit, often with adjustable interest rates that increased over time. As home prices peaked and interest rates rose, many homeowners found themselves unable to afford their mortgage payments, resulting in a wave of defaults and foreclosures. This flooded the market with distressed properties, causing home values to plummet. For buyers, the crash created both challenges and opportunities. Those who had recently purchased homes at inflated prices found themselves underwater, meaning they owed more on their mortgages than their homes were worth. This made refinancing or selling nearly impossible, trapping many in financial distress. This also led to a mountain of short sales in the market. On the other hand, buyers with financial stability and access to credit were able to purchase homes at historically low prices as banks and distressed homeowners were forced to sell at steep discounts. If a buyer could hang on to their property and wait it out in the years to come, they would be able to recoup their investment and possibly even end up with equity. For sellers, the crash was devastating. Homeowners who needed to sell faced declining property values, often selling at a loss or being forced into short sales or foreclosure. Many sellers were unable to find buyers due to tighter lending standards, making it difficult to move or downsize. Investors also experienced losses, particularly those who had over-leveraged in speculative real estate purchases. Overall, the crash led to stricter lending regulations, a slowdown in housing construction, and significant economic consequences, including job losses in real estate, finance, and construction. The ripple effects of the crisis influenced the housing market for years, reshaping mortgage practices and buyer behaviors, who made out in the collapse of 2008-2009. While the 2008-2009 real estate collapse devastated millions of homeowners, some individuals and institutions benefited greatly from the downturn. While the average homeowner and middle-class Americans suffered, savvy investors, hedge funds, private equity firms, and well-positioned financial institutions profited immensely from the collapse. The crisis widened the wealth gap, as those with capital and market insight were able to turn the disaster into one of the biggest financial windfalls in modern history. Those who profited the most included hedge funds and investors who bet against the market. Some investors foresaw the collapse and shorted the mortgage-backed securities (MBS) market, making billions when housing prices plummeted. Michael Burry, Scion Capital, the hedge fund manager, famously predicted the housing market crash and made hundreds of millions by betting against subprime mortgage securities. John Paulson, Paulson & Co. Paulson's hedge fund made an estimated $15 billion by shorting the housing market, making it one of the most profitable trades in history. Institutional investors and private equity firms. Once property values crashed, cash-rich investors took advantage of the distressed housing market by acquiring foreclosed homes and rental properties at record low prices. Blackstone Group, one of the biggest winners, Blackstone purchased tens of thousands of foreclosed homes at bargain prices and turned them into rental properties, profiting immensely as home values rebounded. Warren Buffett's Berkshire Hathaway. Buffett's firm invested heavily in financial institutions and real estate-related businesses at the bottom of the market, benefiting from the recovery. Banks and financial institutions that were bailed out. While many banks suffered losses, some were deemed too big to fail and received massive government bailouts. Goldman Sachs and J.P. Morgan Chase. While some banks collapsed, these financial giants survived and thrived, partly due to government intervention and their ability to pivot amid the crisis. AIG, American International Group, the insurance giant, which had sold billions in credit default swaps, essentially insurance against mortgage defaults, received a $182 billion government bailout to prevent total collapse. Wealthy homebuyers and real estate investors. Buyers with cash or access to credit snapped up foreclosed homes at deep discounts, turning them into rentals or waiting for prices to rise. Real estate investors and house flippers capitalized on distressed properties, acquiring assets at rock-bottom prices and selling them years later for huge profits. The Federal Reserve and policymakers who reshaped the market. The Federal Reserve pumped trillions of dollars into the economy through quantitative easing, QE, and low interest rates, stabilizing financial markets and boosting asset prices, including stocks and real estate, favoring the wealthy. Government programs like TARP, Troubled Asset Relief Program, rescued financial institutions, allowing them to recover while many ordinary homeowners still lost their homes. Here's an example of a borrower defaulting on a mortgage in Arizona. This example illustrates how a borrower defaulting in Arizona can lead to non-judicial foreclosure, and how Arizona's anti-deficiency laws can protect homeowners from further financial liability. John and Sarah, a married couple living in Phoenix, purchased a home in 2019 for $400,000 with a conventional mortgage. Their monthly mortgage payment, including principal, interest, taxes, and insurance, was $2,500. Missed mortgage payments. Default begins. In 2024, John lost his job, and Sarah's income alone wasn't enough to cover all their expenses. They missed their June and July mortgage payments, officially defaulting on the loan. Notice of Default, NODE, issued. In August 2024, after 90 days of missed payments, their lender issued a Notice of Default, NOD, informing them they were in breach of their mortgage contract. The lender warned them that if they did not bring the loan current, the property would be scheduled for foreclosure. Notice of Trustee's Sale filed. By September 2024, after continued non-payment, the lender filed a Notice of Trustee's Sale, setting a foreclosure auction date 90 days out. Under Arizona's non-judicial foreclosure laws, the lender was not required to go through the court system. Attempt to avoid foreclosure. Facing the possibility of losing their home, John and Sarah explored options. Loan modification. They contacted their lender to request a modification, but their financial hardship didn't meet the lender's criteria. Short sale. They listed the home for sale at $375,000, less than their mortgage balance. However, finding a buyer in time proved difficult. Reinstatement or repayment plan. They were unable to come up with a lump sum to reinstate the loan. Foreclosure auction and eviction. By December 2024, with no resolution, the property was auctioned at a trustee's sale. A real estate investor purchased it for $325,000, below market value. After the auction, John and Sarah received a 5-day notice to vacate. Unable to negotiate additional time, they moved out before facing eviction proceedings. Impact and aftermath credit score damage. Their credit scores dropped 150-200 points, making it difficult to qualify for new loans or rental properties. Arizona's anti-deficiency law applied. Since the property was a single-family home on less than 2.5 acres, and the mortgage was a purchase money loan, the lender could not sue John and Sarah for the remaining balance. Future home ownership. They would likely need to wait at least 3 to 7 years before qualifying for a conventional mortgage again. Let's talk about the anti-deficiency law. Arizona's anti-deficiency laws offer strong protections for homeowners who finance their primary residence with a purchase money loan but do not protect borrowers who refinanced, took out HELOCs, or invested in rental properties. Arizona has anti-deficiency statutes designed to protect certain homeowners from being held financially responsible for a remaining loan balance after foreclosure. These laws prevent lenders from suing borrowers for the difference if a foreclosed home sells for less than what is owed on the mortgage. Here is an explanation of the anti-deficiency law. Key Arizona Anti-Deficiency Statutes, ARS, Paragraph 33, 729A, Judicial Foreclosures, applies to mortgages. Protects borrowers if the loan was used to purchase a single-family or two-family home. The property is 2.5 acres or less. If a lender forecloses through the courts, judicial foreclosure, and the above conditions are met, the lender cannot pursue the borrower for any remaining balance after the foreclosure sale. ARS, Paragraph 33, 814G, Non-Judicial Foreclosures, applies to deeds of trust. Arizona primarily uses deeds of trust, which allow for non-judicial foreclosures, trustees' sales. If the foreclosed property meets the same conditions, single-family or two-family home, 2.5 acres or less, and the loan was purchase money, the lender cannot sue the borrower for a deficiency judgment. Exceptions: when lenders can seek a deficiency judgment. Refinanced loans and HELOCs. If the loan was refinanced or a home equity line of credit, HELOC, was taken out, the borrower may still be liable for any remaining balance. Investment properties and commercial loans. The law does not protect borrowers if the foreclosed property is an investment property, vacant land, or a commercial building. Cash-out refinances. If the borrower took cash out in a refinance and did not use it to purchase or improve the property, the protection may not apply. Example of how Arizona's anti-deficiency law works. John buys a Phoenix home for $400,000 with a purchase money mortgage. After defaulting on the loan, the house is foreclosed and sells for $350,000 at auction. If the loan was purchase money used to buy the home, the lender cannot sue John for the remaining $50,000 balance. If John refinanced the loan and later defaulted, the lender could pursue him for that $50,000. In Arizona, the legal framework concerning loan defaults encompasses several key statutes. Statute of Limitations on Debt Collection. Arizona Revised Statutes, Paragraph 12, the 548, establishes a 6-year statute of limitations for initiating legal action to collect debts founded on written contracts, including promissory notes and credit card agreements. This means creditors have 6 years from the date of default to file a lawsuit for debt recovery. As defaultlegalservices.com, interest rates on defaulted loans. According to Arizona Revised Statutes, Paragraph 44, 1201, the default interest rate for any loan, indebtedness, or obligation is set at 10% per year, unless a different rate has been agreed upon in writing. This statute also outlines interest rates applicable to judgments on debts. Arizona legislature definitions related to loan defaults. Arizona Revised Statutes. Paragraph 6-991 provides definitions pertinent to loan defaults, including the role of individuals who, when a borrower is in default or at risk of default, work on behalf of the note holder to modify obligations to avoid foreclosure or facilitate the foreclosure process. Arizona Legislature. These statutes collectively guide the processes and limitations associated with loan defaults in Arizona.